very much. Again, just a real quick introduction about me and who I am and a little bit of the experience that I have with this law. I've been doing HIPAA compliance consulting since, well, 2003 for all intents and purposes, back when the HIPAA security rule came out, which put in regulations to ensure that we're securing electronic protected health information as well as any paper-based or verbal disclosures. Obviously, throughout those years, at least up until 2009, this law really wasn't being enforced. It was there, but you very rarely saw an audit actually occur. Of course, times have changed. That all began in 2009, but really took traction in late 2013, and I'll give some specific examples of that as we move on. I personally conducted over 1,000 risk analysis for covered entities and business associates throughout the United States, from very large hospitals to small clinics to very large businesses down to small little businesses developing an iPhone for an app. So I've pretty much seen every possible way that health records can be accessed, transmitted, or stored throughout the years. I've also worked on behalf of the federal government as a contracted auditor on their behalf. So when I approach this, I'm not only looking at things from a perspective, are we securing health records, but are we doing things properly to succeed in an audit, should an audit occur? And more importantly, in the last couple years since the 2013 Omnibus Rule, I've done a lot of work in litigated cases, and this is probably the most dangerous aspect of the changes in this law. It's the individual remedy. The federal government snuck legislation in there back in 2013, basically granting the state's attorneys generals to implement laws of remedy for citizens of a state for federal HIPAA violations. Even though you're suing under state law, you use the HIPAA violation as that foundation of the state case of negligence. And I've received multiple calls from attorneys, both prosecution and defense, needing expert witness help in these litigated cases. And to be honest, this is becoming a pretty big nightmare. And we'll talk about that as well as we move through this. So without further ado, let's jump into this. And there'll be some time at the end for some Q&A. I'll try to wrap this up, 5 minutes early or so you guys can ask some questions of me, because I know this is a very broad subject here. So let's talk about what's going on. And that's just my little bit of the bio there. So if you recall, in the past, this law has basically left us alone. It really has. Yes, it's been on the books, but what's the purpose of a law that's not really being enforced? And it wasn't in the past. But unfortunately, it is now. And with a little help from Photoshop, we being the kangaroo and the federal government, along with the trial attorneys, being the shark. So bottom line is, we've got to be proactive with our compliance. I'll say this over and over and over again, and I can't stress this enough. You've got to be proactive, not reactive, because regardless if it's the federal government coming after you in an audit, or if it's in a litigated case, either way, you're going to have to prove that you have done your due diligence to secure this protected health information in, quote, reasonable and appropriate ways. Because if you cannot prove that, that's how you get held to the fire. None of this is rocket science, but you have to go through the requirements that the government says we have to do, chiefly being doing your HIPAA security risk assessment, making sure you have policies and procedures in place which cover those implementation specifications of the HIPAA security rule. And we'll get into more of that as we move on. So real quick, the acronym, Health Insurance Portability and Accountability Act of 1996. So that's when it was signed into law. And it's interesting, when you look in the acronym, the words privacy and security aren't even mentioned. But by far, that's our biggest challenge. There's a whole lot more to this law than what we think. Most of us, when we think of HIPAA, we think of, securing health records, don't disclose health records, make sure they're accessible. But there's a lot more to it. Technically, the whole concept of the law was portability of your health insurance. So obviously, lots of changes, and again, you've got to be proactive and prove that we've done the things that we have to do under the law because if you don't and something bad happens, you're going to have a problem. So a little bit like the boy who cried wolf in the past, you know, the government for all these years, do this, do that, do this, do that, but they weren't enforcing. So it created that dangerous situation where people essentially sweep it under the rug and just ignore it because it's not being enforced. But then all of a sudden the wolf shows up, and again, I jest with these pictures, but in all seriousness, I get calls every single day from groups all over the country stating, oh no, we are being audited by the Office of Civil Rights for HIPAA. What do we do? What do we do? Or we're being sued, or we're trying to sue from an attorney for a violation of HIPAA using state law. Again, in either case, whether you're dealing with a litigated case or whether you're dealing with the federal government in a HIPAA audit, you've got to prove that you were not being negligent. Another thing, if you're not writing policy and procedure, putting in things in writing, essentially we're not doing it. Because a lot of HIPAA, a lot of being compliant is doing the risk assessment, getting those policies in writing. And if we're not writing it down, we're not doing it, or we have to jump through hoops to prove that we are. So prior to Omnibus, and that's what we're talking about. We're talking about where are we now? How did everything get to where it is? Prior to that date, September 23rd, 2013, that's really when everything changed. That was about, what, three and a half years ago now, and, you know, it takes some time for government to get traction, but there has been a massive, massive increase in federal proactive auditing since that date, and also the law is being enforced directly to business associates. So prior to Omnibus, we were dealing with more of a poodle like this. After Omnibus, if you leave this alone, if you ignore it, it's just like my dog. If left alone and not tended to, it will destroy things. So after Omnibus, after that date, September 23rd, 2013, we're dealing more with a honey badger. If you know what these little critters are, they are very, very dangerous. So let's talk about 9/23/2013. That is the proverbial D-Day of HIPAA. That's when the law really, not a ton of changes, but that's when it went into real, true enforcement. So